There is a camera on a pole somewhere near you. Maybe it is at the entrance to your neighborhood. Maybe it is mounted on a traffic light on your way to work. Maybe it is outside your church, your school, or your doctor's office. Every time your car drives past it, the camera reads your license plate, records your location, and logs the time. That record is stored, and depending on who installed the camera and what agreements they have signed, it may be accessible to law enforcement agencies in your state, in other states, or at the federal level. The company behind most of these cameras is called Flock Safety. As of 2026, more than 5,000 law enforcement agencies and 12,000 clients total across the United States use Flock's technology. The company recently crossed 100,000 cameras deployed nationwide. Tonight on Words with Wentz, we are documenting what those cameras actually do, what the audits have found about where your data goes, and what the Supreme Court of the United States has said about the constitutional limits on exactly this kind of surveillance. We report what the documents say, and tonight the documents are significant. If you watched episodes 1, 14, and 15 of this series, this episode is the physical world version of what we documented there. The geofencing was on your phone. This camera is on your corner. Same constitutional question, different hardware. Automated license plate readers, ALPRs, use pole-mounted cameras, optical character recognition, and machine learning to scan and record every vehicle that passes their field of view. Not just vehicles of interest, not just suspects, every vehicle. The public safety case for this technology is genuine. Flock safety cameras have been credited with recovering stolen vehicles, locating missing persons, and generating investigative leads in serious crimes. These outcomes are real and they are documented. The technology works by creating a travel log, a record of where a specific plate was seen, when, and at which camera location. When law enforcement agencies share data across jurisdictions, that travel log can extend across city limits, county lines, and state borders. The data is typically retained for 30 to 90 days, depending on the contract. Here is the constitutional tension the technology creates. The Fourth Amendment protects against unreasonable searches and seizures. Traditionally, courts held that information visible in public, including a license plate on a public road, carries no reasonable expectation of privacy. You chose to drive in public. Your plate is visible to anyone, but the Supreme Court has recognized that technology can change the constitutional analysis when it enables a kind of comprehensive, sustained surveillance that no individual officer could conduct manually. That is the legal question this episode is built around, and the facts that have emerged in 2025 and 2026 make it significantly more urgent. I want to tell you about the specific documented events that changed this story from a policy debate to an accountability crisis. In Illinois, the state launched an audit after it emerged that Texas law enforcement had used license plate reader data from Illinois cameras to track a woman who had traveled to Illinois to receive abortion care. Illinois law explicitly prohibits sharing plate data for immigration or abortion-related investigations. The audit found something that went further. Flock Safety had allowed U.S. Customs and Border Protection to access Illinois license plate cameras through a pilot program that, according to Flock's own statement, Flock's own leadership was unaware of. The audit found 47 agencies had to be removed from access to Illinois cameras. One city, Evanston, ordered the cameras removed, then discovered that Flock had reinstalled some cameras without the city's permission, leaving them actively collecting data. Evanston issued a cease and desist. The cameras were not fully removed until early 2026. In Mountain View, California, the police chief disclosed that more than 250 unapproved agencies had searched the city's cameras, approximately 600,000 queries in 12 months, without the city's authorization. The council voted unanimously to terminate the contract. In Washington state, 8 local agencies had enabled direct data sharing with U.S. Border Patrol in 2025, in some cases without the knowledge of the cities that owned the cameras. The state legislature passed a law in 2026 requiring warrants for most ALPR data sharing with federal agencies. And on July 14th of this year, 4 days before this episode was recorded, the Los Angeles Police Commission voted to suspend all new flock safety camera installations, pending a full reassessment. As of this recording, more than 53 cities have terminated their flock contracts. These are not hypothetical privacy concerns. They are documented, audited facts. The Supreme Court has spent 60 years building the constitutional framework that applies to this question. 3 cases are essential. Katz v. United States, 1967. Before Katz, the Fourth Amendment protected physical spaces. The court reversed that. The test established a person has a reasonable expectation of privacy when they have a subjective expectation of privacy, and when society recognizes that expectation as reasonable. The Fourth Amendment protects people, not places. United States v. Jones, 2012. Law enforcement attached a GPS tracker to a vehicle and tracked movements for 28 days. The court unanimously held this was a Fourth Amendment search. Concurring justices raised the additional question of whether aggregated location data over time creates constitutional concerns beyond the physical act of attaching the device. Carpenter v. United States, 2018. The government obtained 7 days of historical cell site location records without a warrant. Chief Justice Roberts held this was a Fourth Amendment search. A comprehensive record of a person's movements, compiled through technology, crossed a constitutional line, even though the data was held by a third party, and even though the movements were occurring in public. Now apply those 3 cases to a network of 100,000 license plate cameras that records every vehicle's movements, retains the data for 30 to 90 days, shares it across jurisdictions, and, as the audits document, makes it accessible to federal agencies without the knowledge of the local governments that installed the cameras. The constitutional framework is there. Whether courts will apply it consistently to ALPR networks is a question that is now actively being litigated. Here is the dimension of this story that the policy debate usually misses. Flock Safety does not only sell to law enforcement. The company has more than 6,000 clients that include homeowners associations, businesses, and private communities. Those private clients install the same cameras. Those cameras feed into the same data network, and the data collected by a private HOA camera may be accessible to law enforcement through the same sharing agreements that govern law enforcement cameras. This matters constitutionally because the Fourth Amendment protects against unreasonable searches and seizures by the government. It does not directly regulate what a private company or a homeowners association can collect, which means the same data that would require a warrant if collected by a police officer can be collected by a private camera, stored by a private company, and accessed by law enforcement through a contractual data sharing arrangement without triggering the Fourth Amendment protections that would otherwise apply. This is the same structural pattern we documented in episodes 14 and 15. Where the government outsources surveillance to private actors in ways that bypass the constitutional constraints that would apply if the government did it directly. A class action lawsuit filed in San Francisco in February 2026 alleges that out-of-state and federal agencies, including ICE, CBP, FBI, and ATF, queried San Francisco's flock cameras more than 1.6 million times in 7 months. 35 states have no comprehensive law specifically governing ALPR use. Many rely on privacy statutes written before this technology existed. The regulatory gap is documented, and it is significant. I want to be clear about what this episode argues and what it does not. It does not argue that license plate cameras are inherently unconstitutional. The public safety benefits are documented. Stolen vehicles recovered, missing children found, serious crimes solved. Those outcomes are real. What this episode documents is a gap between what these cameras were sold as and what the audits show they became. They were sold as local crime-fighting tools. The audits show they became a de facto nationwide tracking grid with data flowing to federal agencies that the installing cities had not authorized, tracking activities like crossing state lines for medical care that have nothing to do with local crime. The constitutional framework already exists to address this. Katz, Jones, Carpenter. What has not happened yet in most of the country is legislation that applies those constitutional principles specifically to ALPR networks operated by private companies on behalf of local governments. Washington State passed that legislation in 2026. California is moving. 35 states have not started. The question for your city, and you have every right to ask it at a city council meeting, is this: who installed those cameras? Who has access to the data? How long is it retained? And has your city signed any agreement that gives federal agencies access to your local plate data? Those are public record questions. The contracts are public documents. You have a right to see them. The documents are in the description. This is Words with Wentz. Know your rights.
Let the signal cut through the noise. Reading between the lines. Every story leaves a trace, unlocking time and space.